the county won't trap coyotes. They'll trap a bear, but they won't trap coyotes. And the coyote, there's 5 of them. They kind of pack up, which is kind of scary.
Do they, can you set a trap for them?
I don't know that I've heard of a coyote trap. I
They
gave
put-
Ruth
I mean, what if you shot one?
I gave Ruth a baseball bat this morning when she walked down to the barn, and she said I could do better than that.
Well, I wanted to thank everyone that's been watching these videos. They've been pretty popular, and I'm incredibly grateful for that. I think a lot of people are getting something from them. And if to that extent, if you have a question that you guys want to ask, you're welcome to ask it. You're welcome to send us in a tangent. We tend to be better when we're on tangents than we are when we're focused. So you're welcome to distract us. But today I kind of wanted to start the year off with a bang. You're fired, right? So this is
Fight me.
terminated contract. We need to close it out. We need to get rid of it. The buyer's not doing what they said they were going to do. The seller refuses to close. Whatever the issue is, Mike, I don't get it. There is no FAR termination form.
I just got that question 4 minutes before this show from an agent on a FAR contract. Honestly,
There's no form.
Well, they
That's
have
what we
a
do.
seller's attorney review form. I think it's addendum Y. If you look under the FAR contract, I told the young lady that unless they have that, they have no right to terminate.
Well, there are times when you could terminate, right? The FAR contract has financing contingencies. It has inspection contingencies. There's an as-is FAR. There's a scenario where if the repairs exceed the 1.5% or whatever the number's in there, maybe the buyer can terminate then. Like there are so many things where we could need to terminate a contract and they don't have it. Sometimes the buyer and seller just agree to terminate. What should we do? What can we do? First and foremost, Dad, how do you terminate a FAR contract? What would you do?
I typically get an email from the client and I forward it to the other side. Sometimes I use the form. If, like I was saying earlier, if it's a condo review period or the as-is period, I just get confirmation from the realtor in writing that notice was given to the other agent within this time period, and we terminate it. We notify the other side, make sure they know.
So I don't want to skip a step here. If you're a real estate agent and your buyer says, hey, I want to walk away, I'm in my condo review period, you told me I have until Monday.
Yeah.
You say, as the realtor, send me an email saying that you wish to terminate, and then I'll forward that email to the listing agent, right?
Right.
And
Done that a million times.
And then it's done, right? The deal is done.
Then we call the listing agent, make sure they got it, because they'll say they didn't get it. So you want to make a note in your file that you spoke to the listing agent and they got it, because that's extra evidence in court if they try to, argue with you over it.
All right, so that is the act of terminating a deal. You can do the same thing in an ABOR contract. You get an email from your buyer, you get an email from your seller, and assuming you have the right to actually terminate, you could then forward it to the other party, and legally you've protected your client. Legally, you've done enough.
Legally. I really think the call is important, though, because not only do you verify they got it, but you get a sense on what the other side's going to do, whether they say, oh, okay, or if they say, we're going to sue.
Right.
So you want to get a sense of the situation.
Absolutely. Mike, does that make sense that, you being the realtor type, does that make sense? Is that enough of like, all right, I have my marching orders?
It makes sense. In fact, you accidentally hit something, and I kind of laughed and thought when you said the buyer usually says, you told me.
Yeah.
They always start the conversation off with, you told me.
You told me I could walk away, and
your fault.
Yeah, so that's step one. Get number one, make sure you're giving the right advice. Make sure that your time frames are correct. I would be more conservative if you have a question about these timelines. For example, I had a deal where the listing agent calculated the timeline a little bit sooner, or that it was ending a little sooner than the buyer's agent and myself actually calculated. So I felt like we were absolutely correct. However, the listing agent was wrong, and I didn't really want to fight the listing agent. I just wanted to play it safe. Let's go by their counting, knowing that worst case, I probably had another day. So keep that in mind. I'm not voluntarily signing up to fight a listing agent about how to count. That's not something I'm
one day makes a massive difference. I mean, when do you start? And it's usually after the effective date. Then you got to figure out, does it include weekends, or does the deadline fall on a weekend?
Right.
So all those things that affect your timeline.
And we've done an entire video on how to count. I would highly recommend people watch that one. I really like that because it sounds silly, but we actually count with 0. That's where you start. Every timeline starts at 0, not 1. So you have to watch that video. It's on youtube.com/Christian Ross to check that one out. So step 1, you got to get an email from the client. Let's just assume it's a buyer. You're in your condo review period. Get an email from the buyer. Forward that to the listing agent. Give the listing agent a call just to make sure that they are aware, that they've seen the email, that it wasn't blocked or some other issue is going on. And then the next question is, well, how do I get my money back? How do I get my deposit? And it could be the buyer or the seller asking where they get the deposit. And that's where FARBAR really lets us down. Now, I've been criticized before, and Dad, I think you have too, of hating on the NABOR forms occasionally. But this is where NABOR really brings it home to us. NABOR has forms for this. They have a deposit release and termination agreement. I like those forms. I think they should be used. And that's when, this is that point when we would do it. So let's say you're on a FARBAR contract. There isn't that form. You're going to reach out to someone like myself or like you, Dad, an attorney that can help draft a form where the buyer and seller agree to release the deposit either back to the buyer or to give it to the seller. That's what we really want. And that form, what it does is it closes the book. It protects the title company or the law firm to release that deposit, knowing that no one's really fighting over this deposit at this point. And so let's look at that form really quick. Let's see if I can share it. So this is my NABOR backdrop. Let's see if I can pin. All right. So we've got a couple of different termination here, and this is the one I wanted to talk to first. The termination and deposit release agreement basically says seller and buyer hereby release each other from all rights, duties, obligations. This is where having an attorney draft something like this could be pretty helpful because
I don't know why you can't use this form with FARBAR, to be honest.
You can, but a Lee County, a Charlotte County agent probably doesn't have access to this form. It's not something that's in their available repertoire. But if you do have access, if you are accessing NABOR forms, this form's great. It's a great form. And the nice thing here, let's say it's a $25,000 deposit that's going to go back to the buyer. We're going to put it right here, $25,000, put the buyer's name, and we're good. You could also split the deposit. 15,000 to the buyer, 10,000 to the seller. And it could go on and on from there. Seller and buyer hereby release from all claims, obligations, liability, any and all real estate brokers and their licensees. I like that too, right? We don't want any loose ends, especially if the real estate agents had any sort of involvement on why it terminated. We kind of want a clean slate. So ultimately, use a form like this. This is the end. This is step 1 is actually giving notice of your termination. And then step 2 is, what are we going to do about the deposit? There are 2 things. Notice, actually terminating, and then what do we do about the deposit? Why does that matter, Dad? Why do we have to, why are they separate? Why, aren't they the same thing?
I think it's implied, honestly. NABOR doesn't specifically say, and the buyer gets his deposit back, but if the contract's terminated, there is no contract, it was the buyer's money.
Well, I'll be a devil's advocate on this. Contract is terminated, it's the buyer's money, but the seller claims fraud, or the seller is counting the timeline differently, or the buyer thought that was a defective item and the seller didn't. So, right, so now they're not agreeing. Yeah, the contract is dead. They've officially terminated, but now we're fighting about the deposit. Those are separate issues. And so to that end, Mike, here's the question you and I talked about this morning. When do I relist? Right? And you and I kind of had a different opinion on this. I would love to hear your take on when do I list from the broker's perspective, protecting the brokerage, protecting all parties involved. How do you think through that? When do I relist?
I'm always concerned about the possibility of two sales contracts on the same property, two ratified sales contracts on the same property. So I always tell our agent that I would love to have some finality to the first one if it's possible. Sometimes it's not possible, and we haven't even gotten into what happens when one side wants to terminate
Right.
and the other doesn't.
Right.
And then they start throwing out specific performance. You know, so it can get complicated.
Yeah.
What I typically do with the second contract is I make the second contract subject to the first contract being terminated. And I make sure the closing date is after the closing date in the first contract. So you don't get buyer's remorse in the first contract.
Yeah, so just to kind of open or peel the curtain back a little bit, the issue that we've seen, the thing that we all worry about is two buyers that have the right to buy the same property.
Right.
Obviously, that's a mess because you can't sell the same property to two different people. So what Mike and Dad, what you're talking about is we need some sort of finality. We need to know that this first deal is dead, that it's officially been terminated before we can agree going forward. Now, it gets really fun, I think, really fun at this point, because this is where strategy, and Dad, you and I love strategy. This is where it really plays in. Because what do we really want as a seller? What do we want as a seller on this buyer, that buyer? What do we want? You and I are both wearing it.
Money.
We want green. We want the money. We really don't care who the buyer is. I mean, sometimes people, they're principled and they don't like what the buyer has done. There's been a falling out. That's possible. But ultimately, we want money. The buyer wants money too. That's the funny thing. That's all they care about. They want some sort of discount. They want a credit. They want their terms, whatever it may be. And relisting the property can create that leverage you need to get the buyer to just close. But it can also—
I worry about buyer number one seeing that buyer number two is paying $100,000 more for the property. So buyer number one ends up feeling they left money on the table. They could have assigned the contract to somebody else rather than terminating it.
Totally. Absolutely. All right. So let's get into this strategy. Let's think through this. We have a valid contract. The buyer sends a termination. Maybe there was an inspection issue. Maybe there was a financing issue. I don't know. Maybe they asked for the seller to come down on the appraisal amount. You know, maybe the appraisal came in low. The seller won't reduce the price, so the buyer walks away. The buyer terminates. But they refuse to sign any sort of deposit release, right? So now we're fighting over the deposit. Is buyer getting it? Is seller getting it? Whatever. Maybe my analogy doesn't make a ton of sense, but they're fighting over the deposit. But the buyer did terminate. They followed your instructions, Dad. They sent an email to their agent. Their agent forwarded it to the listing agent who received it, right? So delivery and acceptance of the buyer's termination, but no agreement on the deposit. And what does the seller want? They want the greenback. They want to just close. That's all they really care about. They're getting squeezed. They maybe have bought something else, whatever it may be. And so one strategy, and usually the first question that Mike, you ask me, or the listing agent asks me, can I relist? Well, it's funny, a lot of listing agents, that's not even what they're worried about. They're worried about, how do I get the deposit to my seller? How do we make this happen? And I kind of change the mindset.
Is it deposit to the seller or the buyer that we're working on here?
Let's say we don't know. The listing agent wants the money to go to the seller, obviously, but we don't know who's going to get it. And the listing agent really wants the seller to get it. The buyer's agent wants the buyer to get it. That's what they all want, right? They have competing interests. And, you know, as realtors, you're not really equipped to deal with that. That's not your realm. You're not an attorney. You're not going to be fighting in court. You don't really have all the answers to a seller because it's complex. There's no real good answer here. But what can you do? You can sell. And so I'll tell listing agents this all the time. Say, you got to keep your job in the right corner. You got to know what your job is, and that is to sell.
So,
The deposit's over here. Talk to Don Ross, talk to Mark Hewling, talk to Ed Sheffy, all these, crazy litigators. Talk to them. They're great. But I'm going to
crazy.
go sell. I'm going to go sell, and I'm going to relist. And then when I send in that relist, Mike Hughes is going to look at it and say, wait a second. You can't sell this. You have a valid contract. And then, then what? Then what, Dad? What do I tell Mike Hughes? Because he's just a thorn in my side at this
Calm
point.
down, Mike, calm down. You're gonna have a heart attack. Relax. This is
Yeah,
okay.
Well, and so what I say is this is all part of the strategy. What we really want is the buyer to just close. We know that the appraisal came in low, or we know that the inspection, we were fighting over a $1,500 radon system or whatever. I had one come up where the buyer didn't like that it was PEX piping. And I'm like, oh my gosh, is this going to be a thing? I don't know. So they're fighting over it. They don't know if it's a defect or not. The seller just wants them to close. So I'm going to list. I'm not going to accept another offer. I'm just going to list. I'm going to make it active. Who do you think is going to be the first person that is notified that it went active? The buyer, the original buyer, their agent. They're going to have all these alerts set up on MLS. It went active. And they're going to call and they're going to freak out. That's exactly what I wanted. It's exactly what I wanted.
A couple of ripples in there. If the money is supposedly going to the seller, the agent also has to decide whether they're going to claim part of it under their listing agreement.
Yeah, well, let's wait on that. Let's not talk about that yet. That's just what I'm really thinking about though is how do we navigate that? And that's exactly what I want people to think about. I want to think about strategy. There are downsides to going this route of relisting it, just trying to get the buyer's attention. Number one, I have seen lawyers bring that up as a reason why the buyer should get their deposit back. Hey, you went and relisted it. The reality is it doesn't matter. But the buyer's attorney is going to try and do everything they can. They're going to bring up every excuse in the book as to why their buyer should get their money back. Right? But it's not a valid legal reason to dispute who gets the deposit. They're separate issues.
Well, it's like why I said, any second contract I'll make subject to the first one being terminated. I would never release the deposit in anything other than a condo review or the as-is time period without the seller's consent.
As a title, you're talking about as the title company.
I mean, if it's a financing clause, you don't know if the buyer made a good faith effort. There could be fraud. You mentioned fraud earlier. So we can threaten them with interpleaders at times. You're going to have to go out and hire a lawyer. And they want a retainer of $5,000 to fight over this. Do you really want to do that, or do you want to sign here?
So I want to make sure we're being pretty clear with people, because Dad, you and I have a totally different role in this part, because we have the deposit in our escrow account, and we're wanting to be able to get rid of it, right? We want to be able to say, goes to the buyer, goes to the seller, here's your check, here's your wire, whatever it may be. But the real estate agent, that's not their job. So I really want to use, if I'm going to give the next piece of advice. So piece of advice number one is how you officially terminate. Get an email from the client, forward it to the other side, call them to double check. That is step number one, officially terminate. Thing number two to think about is strategy. How do we move forward? And the key is I want the real estate agent to keep focus on what they were hired to do. Mike, you and I, we talked about the buyer brokerage agreement last week. Previously, we've talked about listing agreements, and the thing I like about those agreements is that they specify what the broker's duties are. In those agreements, does it say that you're supposed to help or litigate, deposit and who gets it and this and that?
Our license doesn't allow us to practice law.
Yeah, you're not allowed to practice law. That's not what you're hired to do. That's not what the broker duties are in representing a buyer or representing a seller or as a transactional. It's just not our job. And it's always a great idea to remind your client of that and say, look, you hired me to sell. I'll let you go talk to the attorney. You deal with that. Any information you have, if the attorney wants questions answered, I'm here for you. But my job is to sell. Let's go do it. And obviously, you're going to want to get your client's buy-in on some of this, but I want to relist. I want to create some sort of leverage to see if that original deal is salvageable. If we're talking about a financing issue, or we're talking about defective items, something that's like borderline, shouldn't be a big deal, but the buyer made it a big deal. I want to see if I can get that buyer over the hump. Can I force them to say, you know what, let's make a deal? But don't, this is the next part of that. Just to you were talking about, Dad, and Mike, you were talking about this. Don't accept a new offer before talking to legal counsel. It's that
Because
simple.
Downing Fry is going to want a letter from the new legal counsel saying it's okay, and they can rely on this letter from the lawyer.
Absolutely. Any brokerage is going to ask to have that verified. I think the safest thing is don't accept an offer. And then, ultimately the advice might be, yep, go ahead. You can accept an offer with no contingencies, or accept an offer, but like what you said, Dad, add these couple of things in. Make it contingent on that first deal being officially done. Make it contingent on the closing date being passed and all this other stuff.
And you referred to this on a side note, Christian. You referred to trying to fix out whatever the repair issue is. Usually my first question is, why are they terminating? And why they're telling us is not always the real reason. So if you can get to the bottom of that, you can get an idea of whether it's salvageable. And if it is salvageable, what can you do? What can
absolutely.
the party do?
So I'll here's the latest example. I had something come up yesterday. We're day of closing yesterday, and this buyer has been a little bit challenging. And I think there were leases involved. So I've actually done a video on this before, that even if you don't think you're a leasing realtor, you probably are if you're selling a house that has a lease, an existing lease. And so that's what this scenario was. There was an existing lease, and we had to account for it on the settlement statement, and someone calculated the proration incorrectly. I think ultimately the issue was that the landlord wasn't receiving the full rental amount because they had to pay commissions. So really they were making, the net was a little bit lower than the gross.
Right.
So the buyer realizes this. There was a mistake done by the title company. It was the buyer's title company. But we corrected them. And when they corrected it, the buyer freaked out. Oh my gosh, this is an extra $2,000. This is obnoxious. This wasn't the deal. I'm from out of the country. I don't have the money to do this. And I'm terminating, and I'm claiming fraud. And like, it was, they were throwing everything at the wall and seeing.
Well, if he doesn't have the money and he's claiming fraud.
And the title company was kind of encouraging it, which I was kind of upset about, because I'm like, no, this is pretty black and white. We made a mistake. My company didn't make a mistake, but a mistake was made on the calculation. It made it onto the closing statement, but before we closed, it was fixed, and it was a $2,000 more that the buyer had to come up with. Yeah. And so I'm talking to the listing agent. At this point, the buyer has said, I'm not closing, I'm terminating, I want my money back. I'm already talking to attorneys, and they tried that on me too. The title
They
company
always say that. They never give you the attorney's name.
Well, yeah, no, of course not.
I have a lawyer.
The title company was like, I'm referred them to an attorney. I'm like, oh, good luck with that. That'll be great. A $2,000 issue on a lease, and you're gonna go spend $5,000 to consult with an attorney. Good job by you. Excellent. So what I told the listing agent was, today is the closing date. There are no contingencies. Seller has fully performed. Tomorrow morning, you relist. And he's like, wait, what? What are you talking about? We relist. I said, tomorrow morning, I guess first we have to send an email saying that you're in breach. The seller hereby terminates. We're claiming the full deposit. We'll send you a termination and release.
You're past the closing date.
It's past the closing date. And I said, we're going to relist, hoping that it gets the buyer's attention. And I said, and if you want, text the buyer's agent today that that's what you plan on doing. He goes, really? I said, yes. Text him. So he texts him. He texts the buyer's agent. He says, just so you know, if your buyer doesn't close today, we're going to send a termination. We're going to claim the deposit, and we're immediately relisting. I've already put in the paperwork. The buyer closed yesterday. Had a complete change of heart. So, and who knows if that
It
strategy.
was all over the $2
caused it.
grand, right?
It was $2,000. I think it was unfortunate that it even happened. The calculation should have been right to begin with, and that's where this job can be incredibly challenging. That once you tell someone something, they don't forget it, and especially when it comes to money, it's almost like you've now stolen from them. So earning someone's trust is really hard after you've initially lost
He
it.
already had the money spent.
He already had
Yeah.
the money spent. I think they ended up having to get a money order from Western Union. So there was some real logistical challenges to making this happen, but we called them on their bluff. That's ultimately what we did. And
Did the
that's
title
what I
company's fee go down, Christian?
say that again.
Did the title company's fee go down to the buyer?
No, and it probably would
that's
have
what I
in most
expected.
cases. Yeah. But it wasn't necessarily the title company that made the error either. It was actually the rental agent that made the error on the calculation.
Okay.
They calculated the total commission wrong, but the form was correct. It's just that when they sent the email, the number was different. So once they corrected it, that's when everything kind of went crazy. So that's wild, right? I mean,
How much
that's
was
a
the
lot.
buyer's
There's a lot there.
deposit, Christian?
So
how much was
it was significant. It was like a 10% deposit. So there was a lot to lose. And I used
Real
that
money.
as well. I told the title company, I said, look, I get it. I'm sorry that this even happened for the buyer. I can understand the mentality that it's hard to kind of stomach this change, but this is pretty black and white. I'm not really here to argue with anyone, but here's our plan for tomorrow. We'll be terminating, we're taking the deposit, and we're immediately relisting. So we're not trying to be mean here. We just can't be played around with. We're kind of over it. So, and there was a whole litany of things. Dad, you and I have talked about for a long time now, that you have to build your goodwill during a transaction. If you're continually taking away from someone's trust in you, when you get to the end of the closing and there's something like this, they're just going to come down on you like a hammer.
It's like a mini marriage. You really got to pay attention and put some work in.
Luckily, it's only 30 days. So everyone should be able to stay married for 30 days, right, Mike?
I'll tell you though, the metaphor I always use with these buyers. I mean, if it's $2,000 he's excited about and the deposit is $50,000, I'll use poker in Las Vegas. Would you gamble $50,000 to win 2,000? And they
Right.
tend to get that.
Well, and so if you understand,
right,
I said at the beginning of this video that the seller just wants the green, right? They just want the money.
Right.
And that the buyer does too. And this example is another example. The buyer just wanted money. It's all they wanted. They saw an opportunity to get an extra $2,000 and they tried. I don't blame them for trying. It just wasn't going to work. All right, so let's look at a couple of these other forms that NABOR does have. I like the forms that NABOR has. I think they can be improved, but I don't know if that's going to happen this year. But let's look at a couple of them. The termination and deposit release agreement, that's the one we just went over. Honestly, that's kind of that's just to resolve the deposit and releases everybody from any claims. If you do one form correctly, it's probably this one that matters the most. So there's that. You have termination of listing agreements. We'll skip those for now. Termination of sales contract buyer notice. So again, a buyer could be giving notice to terminate and a seller could be giving notice to terminate. So they've created these forms to kind of go one way or the other. So this would be a buyer giving notice. They have all the different NABOR addendums, all the reasons why there might be a termination. So as is sale addendum, appraisal addendum, backup contract addendum, defective drywall disclosure, homeowner document, all these. It also references sales contract paragraph 7, existing leases with post-closing occupancy, lease information unacceptable to buyer. Dad, you and I talked about this earlier, that the leases had to be reviewed. And then when they came in, the buyer wasn't really happy with what he found and he could terminate. So this references their right to terminate specific contingent.
Well, it could be a sweetheart lease where it's way below market, for a really long period of time. And
Yeah,
they
or
don't want to be
I
locked into that.
always reference there's price and there's terms. The price might have been great, but the terms could have been terrible. It could have been that there
Mhm.
were dogs allowed and they were going to over occupy the property, maybe even beyond rental laws. It could be that, there was no deposit. So even though the price was great, the no deposit put the buyer at risk that they weren't interested in. So terms matter. In fact, Dad, we look at commercial leases. Is
Yeah.
there a personal guarantee or not? That matters. It really
That's huge.
does. Title defects is the next one. So that's standard B issues. Sales contract standard D2B, seller refusal or counter of buyer election to remedial action.
Some of these things would not apply to FAR, unlike
A
the
lot
first
of
one.
them would not apply to FAR. I would say almost all of them. You couldn't really use this for FAR bar. But I do like this language right here. Buyer hereby terminates the contract and requests the release of the buyer's deposit to buyer. Buyer certifies that this notice is delivered within time period required under the contract and that buyer has the right to unilaterally terminate the contract. So we're warranting that the buyer has the right to terminate and that we are officially terminating. This
I
part
like
is
the next paragraph.
yeah, we referenced
Yep.
this a little bit before. The escrow/closing agent may require seller and buyer to sign a termination of sales contract and deposit release agreement. So that's that other form.
It's like your financing example where one side's alleging fraud. We would require this.
Yep, absolutely. And this is our job. This is something we may require. The deal could still be terminated. You've given your notice.
Right.
Today's the day. But if you don't get the deposit release signed until tomorrow, that might be okay. That might be okay.
Hey, let me ask you something, Christian. What would happen on that form that you just had? What would happen if the buyer signed it at the bottom, dated it, et cetera, but forgot to check off one of those boxes?
Yeah,
He's not,
it could be a
not really
problem.
telling you why he's terminating.
It could be a problem. We do potentially need to know why, but maybe not. I don't think it would be a major issue in most circumstances because what we're ultimately doing is we're saying, hey, Mike, I terminate. I want out. It's official. I'm no longer your buyer. The next question is, well, why? Oh, I forgot to answer why. Why is important as to where the deposit goes. It's not necessarily important as to, hey, I've actually terminated. It's like,
But this thing says pursuant to the the terms of the below attached certificate or addendum. It starts out saying this is why. You're
it
better
starts
off
out by
not
saying,
saying that.
I don't think it would be fatal, Mike. And
Right.
ultimately, if I was a title company or a closing attorney, I see this form, I'm gonna want the deposit release form anyways.
You just cross out the whole top and initial it, and then just start with buyer hereby terminates the contract. If it's the as is or the condo review period.
Let's look, I've got a couple of questions here that I want to get to. Let's see if I can find them. All right, so no insurance reasons to terminate. We're getting very low insurance quotes that are existing from sellers, and then we get new quotes that are double or triple in cost. Kim, that's awesome because the next thing I wanted to show you is the financing contingency termination notice. So I pleaded with NABOR to change the name of this form. I think all the termination forms should start with the word termination. I got pretty lucky. They changed 5 of the forms to termination. They still haven't changed this one. This one is specifically for finance contingencies. Now, Kim, this is the only contingency that relates to insurance issues. So on a NABOR contract, there is no insurance contingency other than like the force majeure issues if insurance isn't available or if it's significantly more than what was initially intended. But that's only in the result of like a storm or some sort of act of God. This is more in lines of you got insurance or you didn't get insurance, but no matter what, it didn't help you on getting the mortgage. So you're actually terminating due to the mortgage. And the reason you didn't get the mortgage is because of insurance or partly because of insurance.
Well,
So
what if you just don't like the amount of the insurance, but you otherwise qualify? I don't see how this helps.
this is only if you had a finance contingency and only if your mortgage got denied because of the insurance being super high. Now, if we've done videos in the past where I've suggested adding an insurance contingency to the mix, but there's no form for that. That's something that you'd have to put in writing in other terms and conditions. You'd say, in the event buyer cannot get insurance, for less than $10,000 annually, buyer may terminate up until the closing date and get their deposit back. Like we could
Yeah,
add that in which case we're going to go back to, Dad, your first suggestion, which was if you need to terminate because of insurance, you're going to send an email to the buyer's agent saying, I wish to terminate. My insurance was way too high. Here's a copy of what I got. It's $15,000. And then we're going to forward that to the listing agent. So there's, NABOR doesn't have a form for everything, but we're close. We'll get there. And that's where you guys should have an attorney within your group that can help give language on that sort of stuff.
See, I still don't see it, Christian, though. I mean, under the NABOR financing, either the property doesn't qualify or the individual doesn't qualify. You could afford to pay triple the insurance on your house. You might not like it, but you still personally qualify, and the property qualifies because you're paying triple for
All
the
right,
insurance.
but that's not always the case, right? So we last week we talked about condos where the insurance isn't good enough. So they're getting denied because the master policy is not good enough to cover the Fannie Mae, Freddie Mac guidelines. So that's an insurance issue that you could terminate under the financing contingency. But then we had a couple of clients this year that couldn't afford the very expensive insurance policy. They couldn't just write a check for the difference. Kim actually mentions in her text that it throws their debt to income ratio. So even if they
the individual doesn't qualify in that situation.
Exactly. They could
In
get
your first example, the property didn't qualify because there was a wrong kind of insurance on the contract.
But that's the point. There are many reasons why you may not have insurance, and it could be property related and it could be borrower related. It could be. I had a buyer who couldn't get insurance because they had an open claim in Tennessee. And we shopped it around to multiple brokers and they all said the same thing. Your insurance claim in Tennessee is a red flag for us. We're not willing to insure. That was a major issue.
The lender will turn down the loan at that point. So you'll get something from the lender saying the property doesn't qualify.
Exactly.
Lack of insurability.
And this is an example where even if the buyer is putting 50% down or more and says, I don't need a financing contingency, I'm good, you might not be. You might not be.
He might be good, but the property isn't.
Yeah, or he's not good because of some issue that he has no control over in Tennessee. So it's kind of wild. There's always something. These things do not protect everybody. There's not one form for everyone. I will say, because I know someone's going to mention it, even though FARBAR doesn't have a termination form, Fannie Mae does. Let's see if this shows. And most people, even if you're not a NABOR form, could use this. It basically says seller and purchaser entered into the agreement whereby seller would sell, seller's obligation is terminated, canceled for the following reasons. And you could put in there, buyer terminated under the insurance contingency. For reasons stated below, the money's getting deposited or released this way, and you have everyone sign it. Most of you will have access to this form if you don't have NABOR. So this is something you could think about. I think that's the downside with FARBAR in general, is that they don't have a form for everything. And I think that's why NABOR was created ultimately, because they saw these gaps where FARBAR wasn't really addressing it. I think I've got a couple other questions here that I wanted to address, if I can. All right. Someone here mentioned an insurance quote contingency. Can that be written in? Jackie, yes, it can be written in. You guys are welcome to email me. My email is christian@rosstitle.com. I will warn you though, I tried this with a particular buyer. So it was shortly after one of the hurricane storms, and we had a buyer that he had lost $5,000 or $10,000 on his deposit because he couldn't close when the insurance was like $30,000. It should have been $7,000. It ended up being 30, and he's like, I'm just not going to do it. He's like, even if I could afford it, that doesn't make sense. And so he had to walk away from $5,000, I think. So
Yeah.
on the next couple of deals, he's like, hey, I don't want that to happen again to me. Can you write some language in that will protect me against insurance being outrageous? So I did, in the event, or buyer may terminate if insurance costs more than 10,000 annually. Something very simple. And we added we made it a little bit more specific, but I don't know if we got a single seller to accept it. And that's the reality, is that any of these strange requests, any of these things that are not a typical form, you're going through the listing agent's perspective and what they're going to think about it. And then how is that going to be presented to the seller and what they're going to think about it? You just don't know. There are almost so many cooks in the kitchen. It's probably not going to get accepted. So you kind of have to weigh that. And Dad, you and I talk a lot, the risk reward. You're protecting your deposit or you're protecting the property. A lot of times you can't do both.
Yeah, or the 2,000 in the deposit. I mean, risk reward, absolutely.
Yeah, the risk reward. And that can be, those lessons can be drawn on almost anything. They can be, if you're doing a backup offer, if you're doing a sale contingency, you could have a huge deposit and a sale contingency, or you can have a small deposit but no sale contingency. I think your risk reward.
Writing stuff in goes to the point that I make often, that you want to make your offer as simple and as clean as possible, so it doesn't raise any fear or anxiety on behalf of the seller, while still protecting your buyer. So what I see a lot of realtors doing, or some anyways, they'll have multiple addenda that do essentially the same thing. I mean, if you have an as-is contract, for example, and you want these other things checked out, like you want a review by your lawyer and so forth, well, all that can be done within the due diligence period. So if you have a pre-printed form that's just simple, without a bunch of addenda or handwritten language, the seller gets a little less anxious when they see it.
Right. So I had this come up yesterday. The seller asked for a standard NABOR contract and a 10% deposit and some other things. I can't remember all of them. And when I talked to the buyer, he's like, you know what I really want? I really want 8 days to look at it. And if my wife doesn't like it, then we need to be able to terminate. And he's like, this current contract, can I do that? And I was like, well, no, you would still be risking your deposit that you have down. And we can do one of two things. I said, we can either have a very low first deposit, maybe 5,000, that if on day 8 you want to walk away, you'd be risking your 5. You'd be walking away from 5.
Yeah.
I said you could do that, or give them the 10% deposit with the offer, but an 8-day as-is contract. And the way I pitched it, and the way we've talked about on this video before, is we're counting weekends. And in this case, we were going to go under contract Wednesday, which is today. 8 days would bring us till
Start counting Thursday
of next week. So it's 1 weekend. Now, if it was 10 days, because the buyer's like, well, what I really want is 10 days. Like, well, 10 days gets you to Saturday, which then pushes you to Monday. So now it's really like a 13-day inspection. I said, that doesn't make sense for the seller. Now you're off the market 2 weeks. So what we're going to do in that scenario, send an email or give a call to a listing agent, say, hey, look, I know what your seller wants. I get it. But after we looked at everything, this is what the buyer's willing to do. We're going to send it to you. You tell me which one you want. Do you want the big deposit with the as-is, or do you want the low deposit with the standard? You choose. So I'll end with 2 things. We always had a mantra, or I did at least. It's a 3-pronged mantra. Get under contract, protect your client, get it closed. You have to do all 3. If you're not doing all 3, either the client's upset with you, you didn't get paid, or it never even happened to begin with. So that's the mantra. It should always be under contract, protect your client, get it closed. And then the last thing, and I've said this before as well, it's price and terms. Usually you don't get both. You can have your price, but it's usually going to be the other person's terms. So just keep that in mind. It's that back and forth. And I learned that also, and this one's cool. Car used car salesmen would always say, they would have this 4-quadrant on a piece of paper. And they'd say, all right, Mike, what can you afford? You want to buy that 350 dually, right? What can you afford
Dually?
monthly? And you say, oh, I can pay 500 a month. All right, we can do that, Mike, no problem. But I'm going to screw you on your percentage rate. I'm going to screw you on your trade-in, and I'm going to spread out the loan over 37 years. You good with that? Let's make a deal.
Yeah.
Deal, Mike. That's how you got.
No
That's how
comment.
you got your current pickup
That's the-
truck, right?
That's kind of how they do it.
That hits a little hard to home, right? No,
37 years is a bit long, Chris, but
37 years is long. All right, guys. Thank you. Happy
Thank you.
2024.
Great topic. Great
Thank you,
topic.
Mike. Good luck. If you guys need help on things like this, feel free to reach out to us. Thanks,
Okay.
guys.
Well, Donna, I spent 4 days taking down my Christmas decorations. I don't want any more 4-day weekends. I heard on Marco Island, they caught a 13-foot python there at Hideaway.
I think that story, it's the story that where it started here, and then everyone that they told, it got a little bigger.
I thought it was 9 feet.
Yeah.
Like the Naples Daily News anyways.
That's still pretty big.
Oh yeah, I could still eat each one of my children individually. That's for sure.
You could put it in the barn with the horses, Mike.
Yeah.